Right, welcome to this second module in the Introduction to Trusteeship series for Workplace Savings Trustees. My name's David Ireland. I'm a partner at Denton's Kensington Swan, and I will be working through the concepts or the principles of trustees exercising discretions in a restricted savings scheme environment. With me today, I'm delighted to have one of the legends of restricted scheme trusteeship and former executive director of Workplace Savings NZ, originally the Association of Superannuation Funds of New Zealand, Mr. Bruce Kerr. So, Bruce, would you like to introduce yourself and say a couple of words?
Sure. Hi, I'm Bruce Kerr, and as David said, I'm a licensed independent trustee working as a professional trustee director. I work on a number of varied schemes in the restricted scheme space and have done now for more than a couple of decades and absolutely enjoy doing it.
Excellent. Thanks, Bruce. Okay, what we're going to do, perhaps we jump on to the opening slide to look at. So this is us, and jump on to the next one, which is just give an outline of the session today about exercising discretions. What I will be doing is working through the bulk of the content for you, with some expert comments and chipping in from Bruce. So Bruce does have a license to jump in and interrupt me if he does think of something to add value for you as you're working through the session. Then at the end, we will work through a few fact scenarios, get Bruce to share a couple of war stories, and just talk through some practical applications of the trustee decision-making process. The background of this, when we do talk about trustees making a decision, we are thinking here about a corporate trustee, recognizing that the bulk of trusteeships now in restricted savings schemes are through a corporate model, where the individuals are directors of the corporate trustee, as opposed to individuals acting as a group of trustees. And just bear that background in mind as we're going through this. We otherwise won't make that distinction when you're exercising a discretion as a director of a trustee or somebody supporting a director or a trustee making a decision. It is the corporate that is the one that's making the call. So by the end of this session, we hope you'll be able to place trustee discretions in context, and in particular distinguish those between decisions, powers, and assessments of fact. We want you to be able to identify the types of discretion that you will exercise as a trustee and have a good grasp of the trust law principles involved when you're exercising a discretionary power. And then, as I said, we'll work through some fact scenarios and wrap up by letting you know what records you should be keeping of your decisions. So let's rip into it. Next slide. Right. So what do we mean by a discretion? It's just any form, any action that does require some form of a trustee decision. So that could be, say, between two or more competing options. An example I've given there is where you've got as to deciding which investment manager you want to select as part of a RFP process, or a decision as to whether or not you should do something, such as whether to pay out a hardship benefit where you have a discretion to do so, or in fact whether to embark upon an RFP process. So that decision itself, you do have a discretion. Do we stick with the status quo, or do we go out for tender, or are we just going to pick the one that we think is the best without going through a process? All of those types of actions are things that require the trustee to make a decision, is the broader concept of a discretion. The distinction is a duty that must be discharged. So a statutory obligation. You are obliged to file your financial statements each year. You do not have a choice. Well, your choice is to either do that or to break the law, and suggest ideally don't do the latter of those two actions, but you need to follow that. So there is really no call to make, and you can quite happily get your administrator to look after that for you. Typically in the trust deed, the sort of wording that you are looking for to flag the fact that you are needing to exercise a discretion as opposed to you having a duty is the use of the word may. So the trustee may do something, as opposed to shall or must or will do X and Y. Other clues are as the trustee thinks fit or as the trustee determines. One of the oddities you will come across in many trust deeds is the seemingly random use of reference to say the trustee in its discretion determines, or the trustee in its absolute discretion determines. It's a margin call as to whether there is actually any material difference between those two things. I think absolute discretion is really just an emphasis of the fact that the trustee does have, well, absolute discretion, but generally discretion means much the same thing. May come through if there was a line call as to whether the trustee ought to have considered additional factors. Maybe absolute discretion will make a difference. But generally not. And Bruce, did you have any thoughts about that particular one, of whether in practice you've come across a difference, whether as a trustee you might step back and say, oh no, we haven't got an absolute discretion here, it's only a discretion?
David, I've got to say I haven't. The point that comes home for me in starting with this slide is to remind ourselves that as a trustee or a trustee director, understanding what the trustee says is really, really important, particularly when it's around looking at payments of benefits to members.
Yeah, great point, Bruce, of going through that. And we'll come through to some of those factors that trustees need to consider in the next couple of slides. So let's jump on to the next one. And I guess just a little list of things that trustees are responsible for that don't involve a discretion. So mentioned in the previous slide, so statutory obligations, duties, things you need to do, regulatory requirements. There will also be trustee directions, so not driven by statute, but just what the trustee tells you must do. And then the last one is assessments of fact, and this is often where there can be a little bit of confusion of have we got a discretion to exercise? Or are we just assessing a factual situation, i.e., has the individual actually been disabled? Yes, no. That's an assessment of fact. There is no discretion as such generally involved in such a decision. You are just deciding has a set of criteria been met. Okay. The little highlighted bit at the bottom of that slide. So exercise discretionary powers is the essence of being a trustee. That is actually what it's all about. That's where rubber hits the road, where you can actually get to add some value from your own personal skill set and viewpoints as to how the scheme should be operated. But most of your non-discretionary decisions and decision-making processes can, and I've suggested should, be delegated to a professional administrator. And that ability to delegate things is often one of the more vexed questions for a trustee to consider, of the extent of delegations and how much you can rely on them and the extent to which you can delegate actions. Bruce, you got any thoughts about delegations of decision-making processes?
Thanks, David. My view is that trustees or trustee directors should use their professional administrator to do everything that the trustee allows the trustee to give them to do. We should concentrate on the things that the trustee says we have a power to exercise our mind over, and do those things.
No, I think that's a nice summary of that. That effectively, as a trustee, you don't need to do everything, nuts and bolts. You can get your administrator to look after for you, but you need to make sure that actually the hard calls, decisions, discretions are actually being reserved to you as the trustee. So that's things that you are not delegating, but to have a consistent and efficient decision-making process is highly recommended, and something that you should probably look to your professional administrator to have in place for you. So
that's what I was trying to say, David. Well done.
Yeah, thanks, Bruce. Okay, next slide, perhaps. Before we get too carried away with congratulating each other. Right. So we need to look at, I guess, as a trustee, one of the things you need to be mindful of is the fact that you want to do something, or you think that a particular action would be a good thing for the members, does not necessarily mean that you're able to do it. If the trustee or the law doesn't give you a power to do something, you can't do it, no matter how desirable you might think the particular action might be. If there is something that you want to do that the trustee doesn't allow you to do, then the appropriate action for you as a trustee is to consider whether it will be appropriate to drive a deed amendment to give you the power to do that thing. Powers in this context is just a broad legal term to describe the things that a trustee is able to do, and that's either personally or via a delegate, as we talked about in the previous slide. Powers will commonly involve the exercise of a discretion as to whether or not to exercise them, other than powers that the law or a trustee will require you to exercise. Hopefully that's fairly straightforward. If we jump on to the next slide. Things we must do as a trustee, and a couple of these things are locked into the Financial Markets Conduct Act now as obligations of a trustee. You can find those in section 143 of the FMC Act if you're particularly interested in that. Your traditional trust law concept, you must act in the best interests of members, and that's enshrined in statute. Just bear in mind when doing that what's good for the employer sponsor of your scheme might not necessarily be good for the members. So the fact that something is advantageous for an employer, a particular action, is not necessarily going to be good for the members, and it's the members whose interests you must have paramount in your mind when exercising any discretions. And what's good for one member may not necessarily be good for the others. So you need to understand the demographics of your members and the extent to which different demographics or groups of members might be affected by particular decisions, and making sure that you are making a decision that is overall in the best interest of the members as a whole. An additional statutory obligation, again consistent with general trust law principles, you must act honestly and in good faith and treat members equitably. You're also required to consider all relevant factors and no irrelevant factors in making a decision. And I think that is quite an important one in your fact-finding exercise when you are being asked to make a decision, is making sure that you have captured all of the relevant factors before you, and that you are not having regard to anything that is not strictly relevant to the decision-making at hand. Okay, we might tease it out a little bit when we get into the war stories scenarios later in the presentation. So let's jump on to the next slide for the balance of the key trust law principles that you need to bear in mind. The first bullet point there, it picks up on a theme that I'd raised earlier in this presentation about not deviating from the terms of the deed, i.e. you are stuck with the deed, that's your roadmap, you must follow it, don't go off the map, right? So things that may or may not be relevant, employer promises to members. Effectively, if an employer has promised a particular outcome or an approach that the trustee might take in exercising its discretions, then if it's not in the deed and you haven't adopted it in your product disclosure statement or other material as a trustee, then those promises are not necessarily relevant. It might be the employer's problem if they have promised something that actually as a trustee you don't have the power to deliver. And even if you do have the power to deliver, the employer promise might just be a factor that you would take into account, making sure that, of course, it is a relevant factor for you to consider, which flows through to ensuring that your disclosure documents do reflect the reality. So if an employer is going to embark upon a particular incentive campaign or engagement with members, really important to discuss with your employer. Will make sure that the trustee is working collaboratively with the employer to make sure that your disclosure documents are reflecting what the employer wants to happen. Important to act consistently, more so that you are predictable as to the outcome that you will get, but you can't be a slave to what you may have done in the past. You also need to act personally in exercising any discretion and subject to any delegation powers you might have under a trustee. And always think about these discretionary appointments that you have made, e.g. appointment of investment managers, are generally things that you can't set and forget, need to revisit on a regular basis. Make sure that you're constantly refreshing and viewing, are these appointments the best thing for our members? We also need to exercise our powers for a proper purpose. Now, all of these principles are very nicely captured in one of the leading superannuation law cases in New Zealand back from the end of last century, which is the Wrightson Limited v Fletcher Challenge nominees case. Bruce, I'm sure you'll remember that one well.
Sure do.
Of course. And that related to, I guess, it was the Fletcher Challenge plan and the establishment of a rights and retirement plan, and just a challenge that was made about the way the trustees went about exercising their discretions. And quite a good little summary from that case, just articulating what the requirements are for a trustee, actually plucked from the submissions from one of the counsel in that case. Effectively, the Justice Fisher in that High Court decision did say that when exercising a discretion, the trustee's decision can only really be challenged where the trustee has either acted in bad faith or for an improper motive, that they've failed to exercise their discretion by considering the wrong question or misinterpreting the trustee, i.e. going outside the scope of the trustee, where they've considered irrelevant considerations, where they've failed to consider relevant considerations. If you reach a decision that is perverse or capricious, so that's the main thing where the court might actually revisit the discretion of a trustee, but usually the courts will say, it's your call, trustee, you need to make that call, and we won't second guess you unless we think you've really mucked it up. So I know those principles all flow through to a superannuation scheme. Often we're asked by trustees, primarily in the family trust type environment, well, this decision is a bit hard that I need to make. Should I go to court for guidance? Just be very careful of doing that. Whilst it might be tempting, and indeed where there's a difficult question of law is something that you will often do to go to court, but just because something is hard does not mean you need to get guidance from the court. Hard decisions are actually at the essence of being a trustee, the things you need to do, and there are examples of the courts telling trustees who do go to them for guidance that actually you're the ones who are supposed to make this decision. You should not have come to court for guidance. You need to man up, person up, whatever the correct PC term is these days, and make the decision yourself. And in fact, going to us for guidance was a little bit weak of you, and we're going to impose costs against you, and those are not costs that you're going to take out of the scheme. You'll need to bear those costs personally, because you ought not to have come to the trustee. If you're going to ought not to have come to the court, sorry. If you are going to take on the role of trustee, you need to be prepared to make decisions, and sometimes those decisions will be hard. But of course, you should and can look for advice to help you make decisions when you are a little bit uncertain. So let's jump on to the next slide. Let's come on to that advice point a little bit later. Types of trustee discretion you might exercise. So we've got your general administrative decisions, so discretions as to how your scheme is managed and by whom. So this includes things like engagement of administrators, investment managers, and discharge of your regulatory obligations. The usual or the traditional concept of trustee discretion really comes down to that second type of discretions being dispositive decisions, i.e. whether or not we should pay out a benefit, and if so, then when and to whom. Now, most of the decisions you're going to make in a restricted scheme are going to be not about paying out a benefit, they're going to be non-discretionary. They'll simply involve an assessment of fact. Is the member eligible to be paid the benefit or not? No discretion there. It's just an assessment of fact. Has the person reached age 65 or whatever the retirement age is? If yes, then they're entitled to be paid out. And often it's a question of an actual obligation to pay out, and you need to front foot that rather than waiting for the member to put their hand up. But those are all just questions of fact. Bruce, any thoughts on that particular one about eligibility to be paid out a benefit or not? Do you have any, I guess, examples of where maybe there's been a delay, members become eligible for a payment and the trustee hasn't worked it out or wasn't aware of it?
No, I think you've summarised that very well, David.
Okay, cool. Just always wanted to make sure you got the opportunity to speak to get your word in edgeways, right? Let's jump
Okay.
on. Let's jump on to the next slide. Right. Okay. Administrative discretions. So there are a range of these, and often it's a case of, I guess, the trustees or the trustee, the directors of the trustee, just making sure they're turning their mind to these sorts of decisions on a reasonably regular basis. So one is amending the trustee. Now, you don't want to do that too frequently. The main people that will thank you for that are your legal advisors to the scheme because of the fees generated by amending a trustee and the consequences of that. However, the trustee is not something that is necessarily set in stone, and it might be with changing circumstances. It would be better for the members if that deed were amended. Usually that's going to be driven by, say, the employer wanting some changes to your scheme or external forces, but it's something that the trustee can and probably should think about proactively in terms of saying, hey, is our trustee still fit for purpose? Another one is the investment options that are available to your members. I know we've still got a few schemes out there that'll be a one size fits all. There is definitely one investment fund, and that is the only option for members. But others will actually have a set of choices. Now, is the set of funds that you've got, is that the appropriate mix for your members? Are we going to have regards to ESG type considerations or not? Those are all sorts of administrative discretions that sit with the trustee to make the call. Yep, you're going to get advice from consultants on that, but you need to make the call. For account-based schemes, often calculating the investment return is an investment decision that you need to make. And unitized schemes, generally not, although you may want to revisit or look at the formula that's used to determine your unit prices. Is not something, again, that's, I guess, something where the trustee is able to influence things, where generally there's not going to be a discretion involved in that. In some of the traditional workplace savings schemes, you'll have a reserve account. There will be a balance in that. Often there will be a discretion as to how you apply the reserve account, although for some schemes, there is no discretion. It's a direction of the employer, or there is at least a requirement to get the employer's consent before you apply the reserve account. The extent of the delegations you got in place, that's an administrative decision. The extent to which you do get third-party administrators or other agents to do stuff for you, or whether you go it alone yourself, which extends to then engaging third-party managers as one of the more important administrative discretions that you can exercise. So that's the range there. Let's jump on to the next slide. Conferring benefits, so which is probably the most, when people talk about exercise discretions, this is the one that we usually springs to mind. Are we going to pay out a benefit and to whom? Now, the payment of a death benefit identified there, generally there's not a discretion as to whether or not you're going to pay out. The member has died, that triggers the eligibility for a benefit to be paid and the requirement for the trustee to pay out that benefit. However, the question becomes actually, who do you pay out? Working through a process for that, need to look at the trust deed. What does it tell you about the potential claimants? Often they'll be identified by a class, say dependents of the member. Therefore, you need to identify who are all the potential claimants. You then might need to make a call about choosing between competing claimants. Often it'll be the member's estate, there might be dependents, there might be a surviving spouse of the member, or people that they have nominated and given that nomination to the scheme administrator, or they've named somebody in their will. And so you need to look at, well, all of those are potentially competing claimants depending upon the wording of the trust deed. And need to consider, well, actually is what the member asked for, is that going to be relevant? Always keep adequate records of what you have done, not necessarily the reasoning that you applied in making your decision. We'll come on to that right at the end of the presentation, including that point about, well, do you provide information to disappointed claimants? And there's some, interesting developments there from the Trusts Act 2019 that is now in force, and I guess rights of beneficiaries, potential beneficiaries to information to bear in mind in that regard. Now, the last bullet point I've got on that slide is the requirement to exercise discretions in good faith. Often we're asked, well, what does good faith mean? The only case law definition of that is not in bad faith. So long as you're not improperly motivated and making a discretion, effectively you are deemed to have acted in good faith. So you could actually say, it could actually be exercise discretions in good or neutral faith. Just so long as you're not in bad faith, that is the requirement there. Then need to look at, yes, are employer, other stakeholder views relevant to your exercise of a discretion when you're conferring a benefit? And is it appropriate to make moral judgments? We might just hold that last bullet point, and look at Bruce shaking his head, I can see on the thumbnail, stealing thunder. We will come on to that when we talk about, say, hardship benefits in practice when we get to the war stories section of the presentation. Well, let's jump on to the next slide. Taking advice. I've mentioned this one earlier about the importance of taking advice and where it might sit in things. So read that quote. This is from the Scott v. National Trust case. It is unsurprisingly a UK case about the National Trust, so a community type trust. It had a policy to end deer hunting with hounds on its lands. So as such, it decided not to review certain licenses to hunt red deer with hounds on parts of Devon and Somerset estates, and instead decided it would only allow shooting as a means of culling the deer population. So obviously those who liked hunting with hounds were not happy with that decision, so they challenged it on the basis that they had not properly exercised their fiduciary obligations in banning the hunting by hounds. One aspect of properly exercising that fiduciary function is that the trustees must be properly informed of all matters relevant to the decision, and that will often include taking advice from appropriate experts. However, the line from that case was that advisors ought only to inform the trustees. Is actually for the trustees to make the decision with that information. In this particular case, I think the National Trust sought advice from a scientist as to the impact on the deers of hunting with hounds. Unsurprisingly, the scientist thought, well, actually that stresses out the deers a bit, and it's not really a nice way of hunting deer, so you should not do it. I think the challenge on that one was saying, well, the trustees had just followed the advice of the expert, and that wasn't an appropriate exercise of their fiduciary function. In the actual case, the evidence was that their decision-making process was sound enough for the court to not intervene. So that last line from the quote on the slide, it is for advisors to advise and trustees decide. If you remember nothing else from this presentation, drum that one into memory banks. So that's how it works when you're dealing with advice. Do not let the advisors lead you by the nose. You get information from them, guidance, and that's all part of making sure you are considering relevant factors and making a properly informed decision. But at the end of the day, it will generally be your call unless the trust deed says that the third-party advisor is the one who drives the decision. Again, we might talk about that little nuance in the scenarios. So let's jump on to the next one, which is the war stories of exercising discretions in practice. We just plucked out 4 different types of discretion that we perhaps are relevant. So Bruce, perhaps on death benefits, I understand you've got a bit of a war story you're happy to share with us.
I have, and I'll try and summarize it as best I can, David. It's from a relatively large New Zealand restricted scheme, and it goes back probably a decade. The scheme had a member who died in service, and therefore a death benefit was payable. And the member prior to passing away had worked through and nominated his de facto spouse as the beneficiary should anything happen to him. So the trustee, in working through its information gathering, was looking at what had happened. Was there a nomination in place? What were the circumstances? And had reached a decision to pay the de facto spouse. They had gone as far as instructing the administrator to make the payment. When all of a sudden there was a knock on the trustee's door, and the trustee was introduced to a woman saying, "I am the wife of the deceased member, and I need to be considered as a beneficiary of the death benefit." So the trustee had to obviously stop the processing of the payment and go back to basics and say, what did we miss? What are the circumstances that we need to investigate? So with some help of legal advisors and some workplace colleagues, they ascertained that the member had been in a relationship of marriage. That relationship had broken down and the couple had separated. And somewhere further down the train, the member had met someone else, had not married, but had produced a child. The decision really was, we have a nominated beneficiary. We have a problem and we need more information. So the trustee endeavoured to find out more about the breakdown of the marriage relationship and what happened at the time. And to the best of the information it could ascertain from memory, it was that it was an irreconcilable breakdown. There was a full and final settlement agreed between the parties, and the husband had moved on and got on with his life. That, I think, was saying to the trustee in terms of decision making that was a clean break. The wife retained the family home from memory, and the husband retained his retirement savings nest egg. And the trustee came to the decision that the benefit should be paid to the de facto wife. And having reached that decision, the trustee sought from their legal advisor a second opinion on their process. From memory, the legal advisor said, "I think you've got it right," and the payment was made. It just goes to show, I think, that there's a lot we don't know about our members, and the process of working through due diligence is really, really important. And that there are quite often many sources we might not think about in terms of where we can seek information. And in this case, having the conversation with work colleagues of the former member proved to be quite helpful.
Cool. I think that's a great example, Bruce, in terms of going through. And in that one, presumably the nomination process under the trustee, that was not a "you shall pay to the member's nominee." It was simply that was just one of a number of people that you could that could be paid out. Yeah. Yeah,
it was more a guidance process. In most cases, or in most of my experience in these cases, the first thing you look for is for the member to have had a will. Look to see whether they've completed a beneficiary nomination form, if that's one of the processes adopted by the trustee, and to see how recent that nomination is. A nomination made 5 years ago might be so out of date it's not worth even thinking to take into consideration.
I think that is a really good one in terms of making sure you are as best placed as possible to make decisions in these sorts of situations, is having a process to make sure that if you do have a mechanism for death benefit nominations or nominations of beneficiaries of death benefits in your trust deed, that you do ask members to refresh, confirm their nominations on a regular basis. So at least you have confidence that the nomination on file is in fact the member's last wish.
It's, I think, equally important to have the conversation with the members about the importance of having a will. And that's frequently a common thing that trustees try to do through their annual reporting or through their member benefit statement. Sorry, it's called something else now, isn't it, David?
Your annual confirmation or leave thing.
Yeah, that one.
The lingo, right?
Yeah. So the learning for that trustee board from that one, albeit it was a long time ago, was it kind of set the scene for the trustee to think about, do we have the most appropriate trust wording around death benefits? And has since moved to amending the deed to pay the estate of the member.
Right. Yeah.
And to, pass all of that angst onto the estate.
Yeah, so effectively meaning sort of removing the discretion from the trustee. What do you think? I know we've heard from some of our clients or scheme trustees will say, oh, well, actually, I thought we should just pay to the estate. What do you think about, I guess, that approach, Bruce, saying actually we've got a range of claimants, the estate is the best thing because that's what the member wanted, so we should just always pay to the estate?
I think if that's what the trustee wants to do, then it should go through amending the trust deed and informing the membership of why they've taken that choice. If the trust deed doesn't say that, I think there's a clear obligation on the trustee to go through the due diligence process and to ascertain all of the relevant facts and to work towards being able to make an outcome based on the facts that they gather.
I think, and that's, absolutely.
I think paying an estate, it is, unless it's specifically stated in the trust deed, a cop out on the part of the trustees.
Yeah, and you don't want to cop out. It also becomes what's called a fetter on your discretion if you actually make a call to say, if we have got a discretion as to 5 different categories of people we could pay a death benefit to, if you say actually we'll always pay the estate, or we'll always pay the person that's been nominated by the member because that's clearly their wish. Actually, if that's not what the trust deed says, if they say that that's just one of the people you can consider, by making a call as to who we're going to prefer or who you should be paid out, your risk is you're open to challenge as a fetter on your discretion. So actually going back to your example, Bruce, had that been just an automatic decision from the trustee to say we'll always pay to the nominated beneficiary, then that would have opened up the trustee to a claim by the widow that came out of the woodwork. In this situation, it sounds like the decision-making process was very robust in terms of going through, of looking at, obviously paying out based on the facts that were known at the time, make that decision, something else comes out of the woodwork. So yes, the absolutely appropriate trustee then needs to revisit the decision. Perhaps no surprise that they didn't end up changing their mind, but it sounded like actually work through a proper process to say, yes, this was the right thing to do. And the fact that somebody else has come out of the woodwork does not mean that they should get a penny out of the death benefit, unless the trustee thinks that was the right thing to do.
Absolutely. It challenged the trustee thinking at the time to work out what were the right questions to ask and of whom.
Cool. Okay, jumping on to the next one, I guess. So dropping down just go back to we're still working through these scenarios.
Here's the guy scratching his head again.
Right. Right, the disablement benefit. I'm interested there about, I guess, often you're relying on an insured component, right? So disablement benefit, you're saying, right, members being disabled, in the absence of an insured benefit, often that's just a, I guess, fact payout. But the insured benefit element adds an extra component. Have you got any thoughts or I guess war stories that spring to mind when we look at insured disablement benefits, Bruce?
Most of the schemes I work with, David, just have death and TPD as opposed to disablement. So in the area of TPD, one of my schemes has adopted a process where it has a subcommittee to consider the TPD claim as a part of the journey of the claim going to the insurer. The subcommittee rests very heavily on the decision-making of the insurer on their behalf. So if the claim is improved, obviously no problem. If the claim is declined, then the subcommittee's role is to lean on the insurer to work out how they made their decision and why they've assessed it as not being total and permanent disablement. So if I back up a bit, in having a relationship with the insurer, it's really important to make sure that the wording of the trust deed and the wording of the insurance policy actually line up. So there can't be any gaps in the decision that the insurer is making under this sort of model on behalf of the trustee subcommittee. So we're all working with the same definition and have the same starting point. So yeah, when the insurer says either at this point we can't see that this person is totally and permanently disabled, but they disabled, or we need more information, it falls back to the subcommittee to work with the member and the members' support people to provide more information. And it's to lean heavily enough on the insurer that we've exhausted all possibility of it being a TPD. And sometimes the downside of that in this particular model is that the claim can be dragged out, and it's a matter of working cooperatively with your insurer to say when is enough, and the decision is reached between both sets of parties that the claim isn't going to meet the threshold of being TPD.
I think one of the, things with that, whilst we've thrown in that disablement benefit there as an example of a discretionary practice, what you have talked through, Bruce, is actually this is just an assessment of fact. And often your TPD claims, it will just be an assessment of fact. And the question is, is the process that you have followed to come through to that assessment of fact and making sure that you are following the formula in the trust deed for determining TPD. The process you've outlined, I think, is quite a sound one. You've got a subcommittee that makes the call. Yes, you get informed by the insurer, who is, after all, the expert in these sorts of things to assess, and then challenge the insurer if they decline a claim to say, well, have they got the assessment of fact right? The only discretion in that example is actually just how far you keep flogging the dead horse to see if you can get a pound of flesh out of it for you or not, and framing that call. Although some scheme trust deeds, I know that we've seen, will actually have your definition of TPD in the deed is whatever the insurance policy defines as the TPD benefit. And that does actually raise a discretion for the trustee, because of course then you're saying, well, when we are seeking the insurance policy, or engaging with an insurer, we've actually got a bit of an open page as to the type of wording that we are willing to insure. And so a very narrow definition of TPD might mean a cheaper premium to cover, but of course that means a narrow range of members that might benefit from it. So if you are in a situation where that is the trustee wording that you are dealing with, just need to be very careful in your selection of the insurance policy that you use for your TPD benefit, because that can obviously influence the ability of members to get a payout on a disablement or not. And something where the cheapest policy is not necessarily the best policy for your members, and narrowest definition is not necessarily the best, but neither is the broadest possible definition. Just need to work out what makes sense in the context of your scheme. I'm not sure if you had any experience with that particular scenario, Bruce.
David, my experience there is more about what is an acceptable level of premia for the member if the member is the one bearing the cost.
Right.
And again, that's a bit of a grey area. It's practice will give you experience in what the right answer is, but it takes a lot of practice.
Yeah. But the grey area point, again, that is an example of the need to get full information, make sure you're making a properly informed call, work through your process, and then just back yourself to say, yep, we've weighed up all the competing considerations and we've picked this particular policy, and that's what we're running with, and that is how you go through it, what's going to be the best outcome for members. So actually, let's look at the hardship benefit. And some scheme trust deeds will say it's a bit like your KiwiSaver scheme. If you are suffering significant financial hardship, then you're entitled to a benefit. Some retirement schemes will say the trustees may pay out a hardship benefit if the member is suffering significant financial hardship. Any thoughts on the process you'd follow there, Bruce?
Most of the schemes I'm involved with, David, have just cloned the wording of what KiwiSaver does. It's, in my experience, it's only the first of the many criteria that people will apply under that becomes problematic for the trustee or the trustee subcommittee. And that's, I am experiencing significant financial hardship and I need to withdraw X thousands of dollars. So some boards outsource the process to their administrator, and some boards have a subcommittee where they choose to assess and make the decision on the hardships themselves. Either way, it's still a process of, I believe, gathering all the facts and interrogating the facts that are put in front of you with the application to know that you are getting told the right story, and then making a decision around whether a benefit could be payable based on the story that's in front of you. So sometimes it's a bit hard to look at a significant financial hardship when the facts are saying this member has just taken his family to Hawaii for a 3-week holiday. The credit card is past its limit, and now they're saying, I'm in significant financial hardship and I need to withdraw retirement savings. So I know it's been in place for a while now, and I work with both of the models that I just talked about, having the administrator do it and a subcommittee do it. And my subcommittee talks with the administrator for another scheme to kind of share experiences and see what learnings there are in working through the decision-making process. And sometimes you still come up with an answer that you give the person all of the money that they have in their retirement savings scheme, and it's not going to cure the problem. So it can be a very fraught experience. And, I really compliment the people who are doing this as their day job for a KiwiSaver provider. It is about building up a model just in this one area, significant financial hardship, of, what are the key markers of significant financial hardship? Is it, a percentage of expenditure of household earnings, or is it a level of discretionary income left after household earnings? Kind of using some of the metrics a bank would use when they're looking to assess a housing loan, for example, taking that sort of model, or is it one where you need to be more socially minded and try and put yourself in the shoes of the member?
Yeah,
I think it's a bit of both, and it's sometimes very, very hard work, and it's sometimes very hard work just to get a clean set of information on which to make decisions.
yeah.
But it's a benefit we provide and one we have to work with.
Yeah, because I think the what you've highlighted is just the importance of having a process. There's not necessarily a right or wrong to the answer, and it might be in circumstances, but you have a process, you follow it. A lot of that will be an assessment of fact, so not actually an exercise of discretion, just assessing is the person suffering hardship, and then a call as to whether you pay out. One of the interesting ones you raised before, when you're talking through that, of an example of somebody's become suffering hardship because they've just paid for a whiz-bang holiday and that's cleaned them out, which comes down to what actually is a moral judgment then appropriate. So in that sort of situation, it's actually the members only got themselves to blame for living beyond their means. That's caused them to suffer hardship, therefore we're not going to pay them out. Is that
Mr. Woodbury had a very succinct answer to that, and forgive me, I'm just struggling to think what it was. Past profligacy can't be taken into account.
Right. Yeah. Interesting. I guess it can't be taken into account as an excuse, or actually saying, well, it's not the fact that they're the authors of their own demise, but more actually that could be relevant where you think actually there's no point in giving Mr. Kerr his significant financial hardship benefit if in fact we have a discretion, because we know there's a high likelihood if he gets all the money, he's just going to put it all on the number 9 at Trentham in the weekend, and that might not go well for him. And
it's also a judgment, David.
That is, it is a judgment call on it. But that comes down to actually, have we got a discretion? And so the fact that, I guess, a concern over, the circumstances giving rise to the hardship, is the payment out going to alleviate the hardship? Is that actually a consideration for the trustee in light of the wording of their trustee? Is potentially something to consider. If, however, the assessment of fact is simply, if the member has suffered significant financial hardship, then they are entitled to a benefit, then a concern that the money might be blown on another expensive overseas holiday is actually not relevant, because you don't actually have a judgment to make. It's actually they're entitled, therefore they get paid out. I'm just conscious of us trekking through we're nearly at the end of our allotted time. So maybe moving on to the next one, Bruce, about just investment options and the exercise of discretion or making decisions in that context. And any thoughts you have around going about making decisions in relation to the appointment of investment managers or altering your SIPO for a restricted scheme, Bruce?
Sure. For me, that's all around the 4 Ps, and that's people, process, price, and
performance, possibly.
Performance. Yep. So you can't look at an investment decision in isolation for any one of those elements. In my view, you need to consider all of them. You need to consider investment option A, B, and C. It's not just to set and forget. It's to review. It's to amend as opportunity presents itself, using a good and sound framework that lets you examine the capability and the intended outcome consequence of making the decision.
I think, spot on. It's it is, about the process you follow. There are going to be a range of fantastic, investment options out there for schemes to select. You are embarrassed for choice in terms of how you go about it, both in terms of the philosophy you adopt, etc. Yep. Really, the key thing is making sure you're making a properly informed decision about each of those 4 Ps of actually what makes sense for your particular scheme. What is the value set of the trustee in terms of the approach you want to take for investing? Get your investment consultancy advice. So one area where you are highly recommended not to try and go it alone, but actually get expert advice.
Absolutely.
to rely upon, albeit still making the choice yourself, and just you get your advisor to work through it. And that includes actually regularly reviewing your SIPO. Is this still fit for purpose? Does this make sense? And reviewing those appointments.
Yep.
Perhaps, Haley, if we just drop on to the last substantive slide, which is record keeping. We often have questions raised about the extent to which records should be kept. And this is something perhaps for the trustee to be mindful of in terms of what is actually recorded. The legal point is members do not necessarily have a legal right to be given reasons for trustee decisions, and that is enshrined in law as a thing that you're not entitled to reasons. But of course, if you are told about reasons, then that does open the door to the courts to perhaps second guess your decisions, or second guess that reasoning. Was it appropriate? A question for you as a trustee is actually, as a matter of good conduct, whether nevertheless you should be giving reasons to members for decisions. And in particular, the most likely circumstance where this might be contentious is where you've made a decision that is not what the member would have wanted, e.g., you've decided not to pay out a significant financial hardship benefit. Thinking back to the previous slide, do you tell the member why or not? Point there from one of the classic traditional cases in this is re Londonderry's settlement, that so long as the trustees exercise their power bona fide and with no improper motive, then their exercise of the power can't be challenged in the courts. Their reasons for acting as they did are accordingly immaterial as far as the court's concerned. However, that sort of begs the question of actually have they acted with improper motive or not acted bona fide, but that's quite a high threshold to reach. Yes, you must be keeping records as part of the decision made, as part of your scheme records. The question is whether you should record all the factors and the information considered. In my view, yes, i.e. you're actually throwing in, we did consider all these factors, and making sure that all those are relevant and keeping track of, let's think, being confident that you have actually taken into account everything that is valid. Now, if you haven't, then fair call if somebody is able to challenge that, saying, well, you should have considered X and Y, a bit like Bruce's example previously of we didn't know that there was a widow lurking out in the background that was suddenly going to spring into the fray. So that was a factor that we hadn't taken into account. And yes, if the door was still open to revisit the decision, then we should do so, because that is a factor that we had not considered. So having a record of the factors that were considered by the trustee in that instance, I think is valid. But actually going further and recording the trustee's reasoning does open the door to a court to second guess and perhaps challenge the reasoning that was followed, and is something to do with extreme caution, as would probably recording alternatives that you didn't actually choose. And it's all part of, providing too much information. I'm recommending the Goldilocks approach, so not too much, not too little. That might not be that helpful in practice, but that's the theme you're going for, right?
Sounds perfect to me, David.
Perfect. You're happy with Goldilocks? Thanks, Bruce. Right. Well, on that happy note, then we'll perhaps go to the final wrap or the final decision slide. So effectively, when you're exercising discretion, make sure you are fair, you are informed, that you operate within the deed, and back yourself to make a decision. If you've got everything in place, then highly likely you're going to be making the right decision. Do that in good faith and just back yourself and do the right thing. That's it for me. Bruce, any final word before we close off?
Just remember, when you're working through decision making, you should keep in mind great member outcomes.
Okay, wonderful ending point. Thanks. Have fun out there, people. Thanks, Bruce, for your comments, and all the
Pleasure.
for making decisions in your schemes. Cheers.
Cheers.